Well, hi there, folks. Bill O'Leary here in this video, and I'm going to be talking about how you can plan for your incapacity. So I'd like to teach you three things in this video. Number one, what it means to be incapacitated from a legal standpoint. Two, how the court system gets involved if you don't plan well and don't have a good incapacity plan. And number three, what a good incapacity plan looks like and the different legal tools that make up a good incapacity plan. So again, my name is Bill O'Leary. I'm an attorney with Legacy Planning Law Group here in Jacksonville, Florida, where we focus on three distinct things: estate planning, wills, trust estates, elder law, and probate. So what does it mean to be incapacitated? Good question. So from a legal standpoint, incapacity means not having the physical or mental ability to make decisions or do certain things. So for example, let's say you have a bank account, but you don't have the cognitive ability to engage in a transaction or to authorize certain actions. That's incapacity. You don't understand the import of the transactions that you're trying to carry out. Or let's say you do have the cognitive ability, but you have physical limitations, and there's some need for you to go to the bank to transact something or whatnot, and you physically can't get there. So that is another type of incapacity. And incapacity normally occurs as a result of, let's say, an illness or maybe an accident. And so basically, when someone is incapacitated, they're not able to remain in control of important affairs like their finances and healthcare decisions. Now, incapacity planning, it's a great tool that gives you a way to become, frankly, better prepared for the time that you won't be able to manage your affairs. And so a good incapacity plan includes a number of important legal documents where you set out the wishes, let's say, for the kind of care that you want if you become incapacitated. Also, you can decide who's going to help you manage your affairs, to oversee your finances, and to make important medical decisions for you if you can. And so by planning for incapacity, you can be confident that your wishes will be honored if you really can't speak for yourself and can't articulate those wishes anymore. First, a quick word as to what happens if you don't properly plan for incapacity. It can become very messy and expensive very fast. Why? Because the court system will have to get involved. Someone will have to go to court and open up a special kind of legal case called a guardianship case. And guardianship proceedings can be very expensive and time-consuming. Our goal is to try to stay as far away from the courthouse as possible. Now, let's talk about doing it the right way, staying away from the courthouse. So there's some important tools that you want as part of your incapacity toolbox. Number one, a durable power of attorney. It's a very important legal tool where you appoint somebody basically to help you with your financial affairs, finances, someone to make financial decisions for you, engage in financial transactions, heck, even to be able to have the authorization to communicate with financial institutions on your behalf. Now, you may wonder, what does the word durable mean for a durable power of attorney? All it means is that the authorization that's granted to the agent continues on even after you become incapacitated. It sort of durates through or endures through the incapacity. And one more word about durable powers of attorney in Florida. They are effective right away on the day that you sign them. And I bring this up because there's another kind of power of attorney called a springing power of attorney, which is not effective unless and until you become incapacitated. Springing powers of attorney are no longer allowed in Florida. Another tool in the incapacity toolbox is a living trust. It's a great tool to make things smooth and easy for your loved ones. Not only smooth and easy when you pass away so they don't get stuck in the probate court for sure, but also smooth and easy while you're still alive and you become incapacitated. With a trust, you can name what are called successor trustees, the trustees after you. You know, when you put a trust together, you typically start off as your own trustee, but you can name backups in case you can't do the job anymore. Well, if you become incapacitated, what happens? Your successor trustee seamlessly steps in right away to handle the trust. and to control most of your finances, assuming that most of your assets are in the trust. Using a living trust along with a durable power of attorney, those two together, they're a powerful 1-2 punch for your incapacity plan. A strong 1-2 defense against the courts having to get involved. How about a designation of healthcare surrogate in the toolbox? A healthcare surrogate designation is another very important incapacity tool that helps you prepare for your healthcare if you were to become incapacitated. This is where you appoint someone as your agent, called your healthcare surrogate, to make medical decisions. And by choosing a trusted healthcare surrogate, you can be absolutely confident that your healthcare decisions will be made on your behalf and that they'll be made in your best interest. Now, importantly, you can make clear in your legal document that you want the surrogate, although involved, that they will not be able to make any decisions if you're still able to speak for yourself and make your own decisions. It's only if you can't make decisions for yourself anymore. Another tool in the incapacity toolbox, a HIPAA authorization. You've probably heard of HIPAA. It's the medical record privacy law. It's why doctors and hospitals, won't talk to you, except maybe if you're a spouse, and they, typically will talk to a spouse. Well, if you have health problems, you may want a loved one to know what's going on, right? That makes sense. And to allow the doctors to talk to them. This is done with a HIPAA authorization legal document. Now, the designation of healthcare surrogate that I just mentioned a couple minutes ago also gives HIPAA authorization as part of that surrogate tool. So what's the difference between both tools? Well, a designation of healthcare surrogate does two things. Number one, it appoints a decision maker for medical. And number two, it grants that person access to your medical records and allows the doctors to talk to them. So in other words, it gives them HIPAA authorization. So it sort of does door number one and door number two. In contrast, a straight HIPAA authorization just does door number two, just gives access without appointing a decision maker. And, I've had clients that say, hey, I really want this family member to know what's going on, to have access to my medical records, talk to the doctors, but I don't really want them to be making the final decision. So that's why we have a separate HIPAA authorization for people like that. The final tool I want to mention in the toolbox, a living will. It's an important tool. And it's where you lay out your wishes for what kind of end-of-life medical care you want or maybe that you don't want. And it says words to the effect, if a doctor determines you have one of three health conditions, I'll go from most severe to least, persistent vegetative state, end-stage condition like kidney failure or terminal condition, and the doctor determines there's no hope of recovery. And the doctor further determines that to give whatever medical treatment is being considered, if all that's going to do is prolong the dying process. So if the doctor checks those boxes, the living will says, don't give me that surgery or that additional procedure, treatment, whatnot, put me on that machine, okay? So again, it's a way for you to lay out your wishes. It's a helpful guide for your healthcare surrogate to have, so they're not guessing what you would or would not have wanted if you can't speak for yourself anymore. So if you'd like to know a little bit more about how you can plan for incapacity, sort of that incapacity toolbox, and maybe how we can help, we'd love to talk to you. So we invite you to schedule a 15-minute discovery phone call by clicking right on the link that is appearing in this video now and takes you to our booking calendar. We'd ask that you like and share this video with your friends and do subscribe to our YouTube channel. So Bill O'Leary signing off for now. Go make it a great day and a better world.